Hey everyone, welcome back. Today I'm diving into a fascinating and crucial topic: how a civil lawsuit can pave the way for criminal charges against public officials. So, what happens when public officials conspire to violate your civil rights? And how can filing a lawsuit under 42 U.S.C. Section 1985 lead to criminal charges under 18 U.S.C. Section 242? Let's break it down. 42 U.S.C. Section 1985 is a federal law allowing you to sue when two or more people conspire to deprive you of your rights. This often involves government officials, judges, or law enforcement conspiring to deny you due process, fair treatment, or equal protection. If you prove a conspiracy under this statute, you can seek civil damages. But here's where it gets serious. When that conspiracy involves public officials abusing their power, it opens the door to criminal liability under 18 U.S.C. Section 242. 18 U.S.C. Section 242 is the criminal counterpart. It makes it a federal crime for anyone acting under color of law, meaning government officials, judges, or police officers, to deprive someone of their constitutional rights. When a civil lawsuit under 42 U.S.C. Section 1985 uncovers evidence of intentional and unlawful actions by government officials, that evidence can be used by federal prosecutors to charge those officials under 18 U.S.C. Section 242. Let's consider a real case: Judge Robert C. Nally, a former Maryland Circuit Court judge. In 2014, during a pretrial proceeding, Judge Nally ordered a deputy sheriff to activate a stun cuff on a defendant who was representing himself. The defendant posed no threat and was calmly reading a statement. Despite this, Judge Nally had the defendant shocked, causing him to collapse and scream in pain. This egregious abuse of power led to criminal charges. Judge Nally pleaded guilty to deprivation of rights under color of law, a violation of 18 U.S.C. Section 242, and faced sentencing for his actions. While this case proceeded directly to criminal charges, it exemplifies how uncovering such misconduct can lead to criminal accountability for public officials who abuse their power. This connection between civil and criminal law is powerful. It means that when you stand up and file civil rights lawsuits under 42 U.S.C. Section 1985, you not only seek justice for yourself but also expose systemic corruption that can lead to criminal prosecutions. If you believe your civil rights have been violated in family court, by law enforcement, or by government officials, here's what you can do. Document everything. Keep records, transcripts, and any proof of misconduct. File a civil lawsuit. 42 U.S.C. Section 1985 allows you to seek damages for conspiracy and civil rights violations. Report evidence to the DOJ. If the conspiracy involves public officials, federal prosecutors may pursue criminal charges under 18 U.S.C. Section 242. Connect with civil rights attorneys. Experienced legal professionals can guide you in building a case. Justice starts with exposing the truth. When public officials conspire to strip people of their rights, they must be held accountable, both in civil court through 42 U.S.C. Section 1985, and in criminal court through 18 U.S.C. Section 242. If you or someone you know has been affected by government corruption, share this video, educate yourself, and take action. Because knowledge is power, and justice begins with those who refuse to stay silent. Thank you for watching. Stay informed, stay empowered, and stand up for your rights.